Wow, welcome back everybody to the next episode, of Realty Remarks. I'm your host, Jerry Dwyer. So we'll go around the room here and make the introductions, and then we'll talk about our special guest.
It's Hannah Beauchamp here as well. And Barbara, if you'd like to say hello.
Hi, Barbara Dwyer here.
And of course,
and we have our special guest here, which is a
drum roll, please.
Our lawyer from Brown Beattie O'Donovan, Vera Dokter's here to answer some questions that we get asked all the time. So we want to make sure that we have a quick conversation here about the importance of using a real estate lawyer for the buy and sell of your new home. So thanks, Vera, for coming. Appreciate it.
Thank you for having me.
Perfect. So we'll get right down to it here. So we have a couple questions for you that are frequently asked questions. So we just want to get your take on this and trying to get it out there to the listening world. So
Vera,
question one.
Vera, when should a buyer contact you?
So I always say it's very personal. For me, as a lawyer, I'd like my clients to contact me as early as possible in the process. But it is important for the buyer to be aware with their lawyer on whether they're going to be charged right away or if a file is going to be opened right away, because you want to know that. With me, we don't generally open a file until the deal has gone firm. Unless it's a condo. If it's a condo and we require a status certificate and we have to order that, then the file has to be opened. I don't generally charge a client as long as they use me for the transaction to review something like a status or to review a new build contract, for example. So I don't normally charge that, but the client would be charged any out-of-pocket expenses. So we're talking about things like the actual status certificate.
Sure.
If we have to incur any costs in any searching in advance, those would be costs that would be transition back to the client would be responsible for. But in terms of legal costs, until a deal goes firm, there is generally no legal or lawyer costs for me. Obviously, that's personal to each lawyer, so you should always insure. The reason we say it's important to contact us early is because there may be things we need to discuss with you in advance. We can look at the contract and say, be aware of this, or this is the process you can look forward to and make you aware of certain things. Like if you're buying and you're only putting 5% down or less than 20% down, you should be aware of, for example, there's mortgage insurance, but the provincial sales tax is something that's out of pocket that you have to come up with as part of your closing costs, and you need to account for that. Right?
And that's a good point. And a lot of people don't know these things. So that's why you're right, it's wise to reach out to you way before they get involved in the process, in the purchase or sale process.
And it seems like every situation is different, and that's why it can be difficult to give a concrete number from the beginning too. But because I find that when I'm working with my clients, that's they want to call a lawyer and just get a number for what the costs are going to be. But sometimes, and correct me if I'm wrong, it really just depends on what needs to happen to close the deal in the end.
It's correct. So I always say to clients, it's hard to say, and even saying it's 2% of the price or 5%, it's difficult to say, because if you're not a first-time home buyer and you don't get, for example, the land transfer tax rebate on a purchase, your land transfer tax is going to be higher. Your land transfer tax will go up as your purchase price goes up. Right? It's going to start jumping. So those are things you as a buyer should be aware of. So we can give you general guidelines around that, give you general guidelines of kind of how the transaction works, what kind of adjustments you can be looking for. But I can't give you specific numbers. I won't know property taxes. I won't know how that adjustment will work out to give you specific numbers. But I can give you a general idea of how it works and the general idea of just kind of how the numbers work out. So that's why it's one of the reasons why I say it's important to reach out early, but obviously within your comfort level. Because if you're not comfortable reaching out to a lawyer until the deal is firm, then that's fine as well. But definitely reach out once a deal is firm, because we want to ensure we meet that title search date. We do not want to miss that. That's an extremely important component.
If I can ask you to explain title search a little bit more, because that's something. Oh, sorry.
Let's pause that.
Okay. I just won't say anything. We'll cut it off after Vera stops saying something.
Do you remember where you were?
She was going to ask
Because I'm
about
trying to
sale.
focus and be
I
in
was
the
gonna say,
in
and
the conversation.
likewise, when should a seller contact you?
Yeah.
Okay, so I'll put that in.
Do you want me to say it?
Yeah, right.
It's because I'm scared of silence.
Okay, go ahead, Barb.
So Vera, likewise, when should a seller contact you?
So same thing for me as a lawyer, as soon as possible. Same thing, we normally wouldn't open a file until the deal goes firm. But with the sale, it's important for us to know and discuss things like if you are not a resident of Canada, you're not considered a resident. There are things like withholding until you get a clearance certificate or certificate of clearance from this Canada Revenue Agency, and in those circumstances, it's something you need to be aware of because there has to be sufficient money to do that holdback, sufficient money to pay your taxes, sufficient money to pay your mortgage, sufficient money to pay your commission. All of that is very important to know in advance. So the sooner you can contact, the sooner we can go through that process and you can know whether, there's going to be any issues on the transaction that we need to address early on.
I think that's smart. I mean, knowing that what the expectations are for the seller, and sometimes that might not seem as urgent in the part of the seller to contact you until they get a firm offer on their house. But knowing what their expectations are or knowing what challenges they may face is important too. So that's a good point to bring up.
Mm-hmm.
Now, Vera, probably the most common question excited new buyers ask us is, when do I get the keys to my house? And what should we tell them?
So what I always tell my clients, and we have this discussion every time we do our meeting for signing is, and it's in our initial letter as well, is you do not get keys until the transaction is fully closed. We are not authorized under our terms, we call them escrow terms, to release keys. So even if they are at our property 2 weeks in advance, we are not permitted to release keys. Once the transaction is closed, and that means all money's been exchanged, all documents have been exchanged, and the actual documents have been registered. So your deed, if you're buying in a mortgage, or the deed if you're selling, right? Because your mortgage wouldn't be something that you would need to worry about if you're selling. Once that is all done, then the keys would be available, okay? Mm-hmm. Keys are available generally these days, actually available at the property. Sometimes it's a lockbox, sometimes it's available through a code through the garage and you access them inside the home. But every once in a while they would be at our house, our office. So they would be in our office and then you would have to arrange to come and pick them up. And we are usually very accommodating and can accommodate like an after 5 pickup if it's necessary, if we close later on in the day. But yes, so that's not until it's closed. So there is no way for me to ever give a specific timeline. The other thing we always tell clients is do not arrange for anything. Do not arrange for Rogers. Do not arrange for Bell. Do not arrange for any of that on the day of closing because, again, we cannot guarantee when you're going to have keys. So we can't guarantee you'll be able to access the property for that.
So just make sure you don't have the mover sitting up front of the house at 9 a.m. waiting for it to close. We try and alleviate that as well from our side to say, it'll close anytime between 9 and 5, potentially, but we really don't know. So we want to make sure that the client's aware, just like you said, and they're not rolling up in front of the house at 9:01 saying, I have the keys, can I come in? If you don't have the keys, you can't rush them out. They could be moving out still that day.
Well, I always think the safest way to approach it is to think worst case scenario and just, if these things get delayed or something like that, that's how you plan it. And then if you get them early, bonus, exciting.
Well, and the thing that a lot of people don't realize is sometimes we're in a chain. So someone is buying your property, but they have to sell their property on that same day. And we don't know how far that person that's buying that seller's property for them to be able to buy your property could also be selling to buy. So we could, there are circumstances where we're so far down the chain that it is a later closing and there's nothing that no one's deliberately delaying. It's just the way the process is, right? So we just can't guarantee a time. On the opposite side, and I know this wasn't a question asked, but something that comes up a lot is when you sell, you are to be out of the property at the time that it sells. It's not 6 o'clock, it's not 5 o'clock, it's at the time of closing. And since we do not know when your transaction closed, my advice to my clients is always to arrange to be out of the property by 10 a.m. at the latest. That's kind of, even if someone is paying cash, chances of it closing before 10 are very slim. So 10 a.m. is usually what I say on the day of closing, that you have to be out of the property.
Okay, that's another one
I'm
too.
glad you mentioned that.
So people don't have their moving truck showing up at noon that day to start packing. That it's showing up early so you can be out of there by 10 a.m.
Yeah, and it's just really uncomfortable for someone who's bought your property and goes to move in, and you're still there moving out. Apart from the liability, right? If someone gets hurt while they're moving out and you now own this property, apart from that, it's just uncomfortable. It's a bad way to end a relationship or start a relationship with someone that's bought or sold your home.
That's a good point. So yeah, make sure if you're selling, make sure you're out of there at a reasonable time too, and you're not delaying that by it closed at 11 and your moving truck doesn't show up until noon. It's a very good point.
It can be a shock too, right? Because you're dealing with your lawyer who's telling you what to do, but the other lawyer might not be telling the other party to do that. So you're showing up to people already on the property. So the more we can
just alleviate that.
Just make it smoother.
That's right.
So Vera, what responsibilities or tasks does the lawyer handle on behalf of the buyer?
So one of the main things we do is what we call a title search. So that is a search of what is registered on the property, and we address certain issues. So things like, which is common, so the seller has a mortgage on the property, so we have to request that mortgage be paid out and discharged off the property, okay? We search for things like easements, and I always explain easements are rights of people over your property. So you would still have the right to utilize that property, but those rights are restricted. So for example, you may not be able to build any permanent structures like a pool or a shed over that easement property. We would look for that, and generally I would explain to you where that easement is located. The easement itself is not usually a problem. It's just more important for you to be aware of where it's located.
Location. Sure.
So we do those types of searches. We generally do that in the background. I always tell my clients, usually I don't reach out to you unless there's a specific problem we need to discuss, because we can deal with that a lot on our end. But that's one of the main things we do. We can go outside of that, and again, discussions we can have, but generally we just stick to what's registered on title. We order a tax certificate. We allow or advise the tax department when you've closed the transaction. We advise the condo corporation if you're buying a condo when you've purchased the property. But it is important that you also make arrangements to submit your paperwork after closing with a condo to ensure that you have arranged to pay the condo fees, for example, because that always ends up being a problem. We obviously deal with all of the issues you have. So if you have any problems, we address them. And usually I say to my clients, I'll talk to you about the potential ways to handle it, but the decision is with you. So I'll give you some options. We'll discuss what you want to do, and then we'll go back. Okay. And then, we handle the actual closing of the transaction, the reporting to you of the transaction, the handling of the mortgage registration, the handling of the signing of the mortgage documents, and the explanation of those sort of things. Important for the clients to be aware that things we are generally not able to do due to privacy legislation is utilities. We just generally are not able to handle.
That's a big one that get asked all the time. Yeah.
Hydro, we're not able to handle gas. Even the transfer of the hot water tank, oftentimes we're not able to open up accounts for people. That's just generally from a perspective of a company. They're not going to allow us to do that for a third party. Having said that, what I tell my clients is if you end up with any issues with any of those companies, I'm happy to go on to a 3-way call. It happens all the time with hot water tank rentals. So I'll go on a call as long as you're present as well and kind of explain. I've done that with insurance because that's another thing the purchaser is responsible for is obtaining fire insurance or property insurance, as you call it, on the property. But I'm happy to assist in any way I can.
I'm gonna call you every time I call Rogers.
Yeah. Maybe not Rogers.
I got a lawyer on the phone.
So that's generally the responsibility of the lawyer on the file on a purchase side.
And so what about seller?
So on the sales side, we are kind of doing it on the opposite side. So we would be taking care of ensuring that we're responding to the lawyer on their title requests or requisitions, as they call them. We are dealing with paying out your mortgage. So we request something called a discharge statement. We take care of paying that out. We take care of paying out the rest of your commission if there's any commission owing. We take care of informing the tax department that you've sold. Again, we advise the condo corporation that you've sold. However, with property taxes and condos, if you're on a pre-authorized payment plan, those are things we advise you to cancel. Oftentimes, especially on a condo, if it's closer to the end of a month, I always tell clients to put a stop payment at the bank as well as an additional safety precaution, because the reality is the chances of you recovering that money if it gets withdrawn from your account is pretty much nil, because it's too costly to do a lawsuit over it. And so I wouldn't say all of them, but most purchasers just don't pay it back to you. So those are things that we take care of. But again, canceling of utilities, canceling of those sort of things, you kind of have to take care of. With insurance, we actually tell clients not to cancel that until we actually confirm the closing has occurred. And that's because we don't know if there's going to be an extension of the closing. It's very difficult to reinstate insurance, to put in temporary insurance. So, we usually say, wait until we tell you it's closed, and then
Confirmation.
Yeah,
that's a good point.
Yeah.
There, for any deficiencies that might come up or a hiccup for a day here or there, it's smart to just keep it.
Yeah.
So the additional cost would be minimal.
Minimal, correct.
So that's good. Great. That's a good point too.
Okay, we're going to take a quick break and we'll be right back with more. Stay tuned.
Vera, what would you recommend for, say, a purchaser? A survey or a title search on the property?
So
Sorry to interrupt you, Vera. What you recommend, but in what instance would there be a survey?
So generally speaking, you're probably never going to get a survey unless it's a brand new build and it's part of your contract. What we generally would do is we obtain something called title insurance. So it's an insurance policy that covers you for certain risks around not knowing where things are in relation to your property boundaries. So, you're not getting a survey. So the idea is that you are getting coverage. So if you have a shed that's in a location that it's not supposed to be, so it's over an easement land, right? And you're required to remove it. It's on someone else's property, or if someone else's property is on your property, that title insurance policy is meant to protect you. So they'll either assist you in resolving that issue, or they would reimburse you for the for the loss that you've incurred. Obviously, that's something that would be worked out with title insurance. That is generally the way we would go, because it's a much cheaper option. Survey is going to cost you thousands of dollars. It's unlikely you're going to get it done in the time frame that's required. And, again, you're getting coverage for a lot less money under a title insurance policy. There are also certain off-title searches, they call them. So those are things that aren't registered on title, but that can still affect your property. Conservation authority issues with work orders, permits, that sort of thing. Generally speaking, the idea is we don't have to search for those, because you're going to get coverage for them under the title insurance policy. Okay. Mm-hmm. But obviously it's your comfort level. If you want us to incur those costs and go and do those searches, we can. But once you know of an issue, you can't insure it. You can't title insure it. And so if the other side can't correct it, you may be in a situation where you no longer can buy the home because they can't correct it and you're not insured for that issue now that we've determined it, right? So those are kind of the things that we could. On a commercial property, it's completely different. On a commercial property, we are required to do specific off-title searches, but on a residential, it's generally not required as part of the title insurance policy.
So title insurance kind of blankets everything, and it's an easier it's an easier to obtain or challenge things when you have title insurance.
Correct. So usually it's meant to cover over these things so you don't incur those additional costs. That doesn't mean it's going to necessarily, because it is insurance, so they can take the position that it's not a covered risk. For example, we've had a situation where there was a problem with a property, but the issue wasn't an existing work permit. It was a not obtaining a permit for work. So that isn't, the title insurance policy took the position that that's not a covered risk. So obviously if you do a permit check, you may get information about the fact that there's no permit for certain work that you know has been done. And then you can address it. If we don't do those searches, you're not going to know that necessarily. Whether you want to know that or not is really up to you, right?
Sure.
As a purchaser.
Sure. Okay. So it's up to the buyer, the buyer for title insurance, and how deep they want to go.
Correct.
Okay. Okay. Those are the most common, I think, that we get as realtors, are what we've discussed so far.
Something that was asked of me just recently. Can a lawyer, yourself, can you represent a buyer and a seller on the same property?
So, in specific circumstances, the Law Society permits it. Whether a lawyer is comfortable doing so is a different story. So what we're talking about is generally if it's a related party. So mother and father, like if you're separating and just doing a transfer pursuant to a separation agreement. If you are child and parent, that sort of thing, yes, because the relationship is there, or you have a specific agreement that already provides, that's been negotiated through usually family law lawyers in the case of a separation agreement. But will we? Like most of the times, most lawyers are not comfortable doing that because we have conflict of interest rules. And those say that if there's a circumstance where the two sides could end up in a conflict, we are going to be unable to act for both parties. So it's not necessarily in the best interests. Having said that, we normally, in these circumstances where it doesn't need to go outside of the firm, so we can have a seller represented by a different lawyer in my law firm, and then the buyer represented by myself, for example. So within the same law firm, we can have two different lawyers handle it. And oftentimes it is a little bit simpler just because money transfers and stuff like that because it's in office. But the conflict rule still applies. So you have to be aware that if there's a conflict between the buyer and the seller at any point, it conflicts out the entire firm. Both lawyers would be conflicted out. So, so yes and no. So sometimes, but not often. Most lawyers are not willing to do it because of the risks.
Well, it sounds similar too with what we do with trying to represent the seller and having somebody represent the buyer's best interest, because we just feel that's what's best, right? So
just you're right, for conflict of interest and what's best for the client. Multiple representation, as we call it in our industry, is something that we don't normally practice because of that reason. It's hard to represent both sides.
If someone wants our help, we don't turn it down, but we explain everything so that they feel comfortable and we feel comfortable and everybody feels they're represented.
Every situation is different.
Yeah, every situation is different.
So Vera, is there anything else that you feel that we should be discussing with our clients in relation to obtaining a lawyer? Anything we should tell them or advise them?
Real estate law.
Yeah, I mean, I think we have the relationship that you can contact me if you ever have questions, right?
Oh, and I do, don't
I? And that's, sorry, that's what I was going to say too. If you're listening to this and you have questions for Vera, for us, that's what we're here for. We're happy to answer any questions you have. Don't hesitate to comment or send us a message.
Yeah, so I think having a realtor that has that kind of relationship with a lawyer helps, because you may not necessarily want to call me. Although I tell my clients, don't stress about things, don't stew about anything, just call me. Because you'd be surprised at the amount of information I have in my head that about things that you wouldn't even think are related. But you can call me and I can at least ease your mind. Why stress about it? I can, advise you, ease your mind, move on from that issue, right? But having that, but generally speaking, I think, realtors and lawyers have a good relationship, or should have a good relationship, so that you can cohesively help the client, right? If you're running into an issue as a realtor, I shouldn't be going against that, right? I should be assisting you or supporting you and the purchaser to get the best results for them, right? So I think that is important to have, is that cohesiveness between the two parties, and it requires some cooperation, obviously, right? In that respect. And I would say probably the other question I get asked a lot is about walkthroughs. Okay.
Walkthroughs, yeah.
So
That's a good
final
one.
walkthroughs on a purchase. And I always say to my clients, that's the time to be picky, keeping in mind that you're only entitled to the state of the property it was in at the time you bought it. It's not better. You're not entitled to a betterment of the property. So I always say, if someone's taken something off the wall and the nails come out and there's like a tiny hole or a tiny like bit of paints come out, that's fine. Like that's not usually something we're going to negotiate out. But if they've been moving out and they rammed some furniture and there's like a good sized hole in the actual drywall, then that's something we should be addressing, right? So I always say 1 to 2 days before your closing, you should do a walkthrough of your property, get a good idea of what it looks like close to your closing date. After closing, it's very difficult to pursue claims, so it's best to know your state of your property just before.
So it is very important to do the final walkthrough.
Very
And
important.
it's funny, we have that conversation. Some buyers are all for it, and some people are like, we're okay. But it's always suggested that the final walkthrough is done. It's part of the agreement of purchase and sale. So we recommend that is done.
And that is something I tell my clients on our signing meeting, because we normally sign in advance, right? So I'm telling them, like, this is why it's important for you to do what your walkthrough. These are the sort of things you're looking for. Run your water for a bit, make sure there's no leaks. And I say most realtors will know all this, and they're going to walk you through it anyways. But, it doesn't hurt. When I was saying to my client, it doesn't hurt to hear it more than once, so it's in your mind. But it is important to do your walkthrough.
We totally agree with that. That's part of the deal. We want to make sure that the home that you purchased is in the same state or very similar to when you purchased it. So that's important. I think we're all on the same page.
And at the end of the day, we're trying to be a team in your corner. We all have our client's best interests at heart, and that's the purpose for making sure you do what you got to do. And I will always make sure you remember this stuff. I can speak for the team that we always
That's a
are
good
reaching
point,
out
man.
to our clients to book that final walkthrough.
Yeah, we don't
if
expect you
hear from
to,
them.
as the client, to know these dates, know these things, but we will walk you through everything. We'll make sure that we're on top of it to keep you informed. So these are done in a timely manner to make sure it's as seamless as possible.
We want to make
the
sure
course.
that place is exactly how you purchased it too,
That's right.
so we can sleep at night.
So for those listening, Vera's comments and notes will be in the
write-up, the
Yes.
synopsis.
Show notes.
show notes.
And if there's any
Show notes.
questions, of course, just reach out and we'll be happy to pass them along to Vera. And that's what's, thank you for being here. And of course,
We'll definitely have you back, Vera, if you'll come back.
yeah, maybe if you guys got some questions, send them in. Bring Vera back. Get her back here.
Good point. We do, you guys out there in the listening world, absolutely. Any questions, always send them to us.
Yeah.
You can visit us on our website or send us through social media. We're happy to discuss any questions that you have and make sure we get you answers for those things.
Yeah.
Okay.
Okay, and for everyone who's listening, clients, family, friends, we're doing a shredded event on May 25th from 10 to 2
10 to 2
p.m. If you have any stuff that you need to shred, we will be hosting an event with our shredded truck for you to get all that spring cleaning done. So if you are
Or if
interested,
you know anybody too.
or know anybody who may be interested, we would love for this to benefit as many people as possible. Please do not hesitate to reach out to myself, the Dwyer team. And
We're always around.
hope to see you there.
That's great, guys. So thank you very much for listening. Until next time.
Whoop, whoop.
Maybe like a